I swear, if I hear the word reasonable one more time, I'm going to have an unreasonable reaction and my head will explode. For the past 2 days, I've been listening to Ontario Superior Court Judge Ed Fenn as he instructs the jury in the Sammy Yatim streetcar shooting, the James Forcillo trial, on the law. And this is a pretty important part of the case. Jurors are responsible for deciding what are called the facts of the case. They decide what evidence to accept, what logical inferences they can draw from that evidence, who they believe of all the witnesses, etc. But the judge is the boss of the law. So in the last 2 days, he's been trying to explain in simple terms what is pretty complicated law. Constable Forcillo, you'll remember, is charged with 2 offenses. Second-degree murder for the first volley of 3 shots, which he fired at Sammy Yatim on the Dundas streetcar on July 27th, 2013, and which we know killed him. These were the lethal shots. And then 1 count of attempted murder for a second volley of shots he fired at the teenager, who by then was lying on his back on the floor of the streetcar at the front. 5 of those shots hit him but didn't kill him. They would have been sort of wounding shots. Constable Forcillo, as a police officer, has 2 defenses, and it's not up to him to prove anything, of course. He's merely the accused. The obligation and the onus is on the prosecutor to prove that these defenses don't apply. One defense is the justification defense. It's Section 25 of the Criminal Code. It enables police officers to use force if they have, and only if they have, reasonable grounds to believe it's necessary for them to do it in the defense of themselves or another person. That's basically it. They also can avail themselves, of course, of Section 34 of the Criminal Code, which is the normal self-defense provision to which you and I would also be entitled. And again, there the test is, did you have reasonable grounds to believe that your life or the life of someone else was in danger or at risk, serious bodily harm, and did you act using proportionate force? So those are the 2 defenses that Officer Forcillo has and which the Crown must disprove. Then the jury has to decide, you know, if the defenses are no good, is this a culpable homicide? That means a blameworthy homicide. Then they have to decide if indeed it's murder, and murder is all about intent, intending to kill or intending to cause grievous bodily harm such that death might follow. That's attempted murder. It's all about the state of mind. And if they were to find him not guilty of second-degree murder, they could still find him guilty of the lesser and included offense of manslaughter. For attempt murder, they have to make similar findings of reasonableness and all of that from the evidence. And the lesser and included offense there is aggravated assault. The judge just said today that he expects to finish his charge to the jury tomorrow, Wednesday, sometime mid to late morning. And then, at last, the jurors in this case will head off to their jury room to deliberate the fate of only the 4th police officer in Ontario to ever be accused of murder.